May it please the court, honorable counsel for the state. This case is about the right of all Iowans, even parolees, to be free from unreasonable searches by government authorities, even parole officers. The Iowa Supreme Court said recently, the poor cottage or ruined tenement of a parolee may be unkempt with lousy heat, running toilets, screens with holes, noisy electric fans for summer relief, and low wattage lighting. But such an abode is still protected by the awesome majesty of the Iowa Constitution from unwarranted searches by government authorities. That, of course, is from State versus Short, decided this past summer. The Iowa Constitution says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable seizures and searches shall not be violated, and no warrant shall issue but on probable cause, supported by oath or affirmation, particularly describing the place to be searched and the persons and things to be seized. Donald King appeals to the Iowa Supreme Court from a district court order overruling his motions to suppress and appeals from the judgment against him. We request that the court reverse the district court's judgment and remand for further proceedings. To put it in lay language, Mr. King was done wrong and the case ought to go back to the district court. Mr. King's parole began in June 2012. Mr. King tested positive for drug use in September and October 2012. After the relapse, he successfully completed inpatient treatment and later attended outpatient treatment. On January 14, 2013, he met with his parole officer, Mr. Emmanuel Scarman. Mr. King tested negative for drug use, meaning he wasn't using illegal drugs. Mr. Scarman said at trial that Mr. King had not tested positive for drug usage since coming back from inpatient treatment. Mr. King said on January 14 that he didn't think he was getting anything out of outpatient treatment and that he was thinking about going back to prison voluntarily. Mr. Scarman encouraged Mr. King not to give up hope on recovery. On January 17, Mr. Scarman visited Mr. King's home. Mr. King had to wear an electronic bracelet for monitoring. The monitor indicated that he had not left his home for 2 days and also signaled a strap tamper. Mr. Scarman testified that
Counsel,
Your Honor,
wasn't that indication to the parole officer that there was an indication of tampering on the bracelet, an indication that they should go to where Mr. King was residing and check it out?
yes, and the gravamen of our appeal is not the visit itself. It is what happened once Mr. Scarman came to Mr. King's house. We're not quibbling over whether Mr. Scarman had a duty to go and investigate that. He did, by the way, find out that there was nothing whatever wrong with the electronic device, found out that Mr. King, at least according to Mr. King's report, had been in-house for 2 days because he had been sick. Mr. Scarman.
So it's your view that once the parole officers determined that the bracelet was functioning,
Yep.
And also checked to see whether he had been drinking alcohol, it was time for them to go?
Essentially, their concerns had been addressed.
Right.
I don't doubt that the reasonableness of Mr. Scarman's initial concerns, the concerns that brought him there. But once he talked with Mr. King, once he examined the device, once he tested Mr. King, and he tested him only for alcohol, if he'd been concerned about a drug relapse, which Mr. Scarman said he was, then he could also have tested him for that. And once all that had been done, the concerns, suspicions, if you will, that brought him there were disposed of. And that's the point at which everything should have stopped.
But you need further suspicion to do a special needs search in taking care of your parolee or person under your care.
The
I mean, that's the issue here.
The state of Iowa has never adopted the special needs doctrine. It has been proposed in a couple of concurrences.
It's been discussed. Why don't you tell us your primary argument as to why this is not a case where the special needs exception ought to be adopted by this court?
Partly because I think that the special needs doctrine is flawed just on its face. I don't think that it stands up under either Iowa law or U.S. law. With regard to Iowa law, since Cullinson in 1970, this court has held that what is required is a warrant based upon probable cause in order to search a parolee's home, that a parolee should be treated just as any other individual. The United States Supreme Court, having enunciated a doctrine of special needs in Wisconsin versus Griffin, in TO versus New Jersey, then has gone off, and has gone off in the form of the Knight's decision and in the form of the Sampson decision.
Well,
the Sampson decision says that there aren't any rights that a parolee has, that you can be stopped and searched without anything other than being a parolee.
But this is different, and of course Sampson and Knight's is completely different and doesn't really rely upon the special needs exception. They take it to a different level, of course. But again, I just want to hear your argument as to why there is a recognized special needs exception. It has been discussed in a number of cases by the court. This appears to be the case directly addressing that. And I just want to know your best argument about why it wouldn't apply in this case or shouldn't apply in this case.
Both generally, the special needs doctrine sets up a difference among Iowa citizens. It says the parolees are somehow in some different category.
But
the
aren't
Cullinson
parolees...
decision ruled very heavily against that.
I'm sorry, Mr. Douglas. Aren't parolees already in a separate category? They lose some constitutional rights, don't they?
They have limits on their rights, and they lose the right.
They lose the right to bear arms, for example?
They lose the right to bear arms.
They lose the right to travel?
Although the right, my understanding is that losing the right to bear arms is primarily a federal matter. But regardless of that, as parolees, their travel is restricted. But they do have the hope eventually of becoming full citizens. More importantly, Cullinson said that these are the ways in which we specifically restrict the rights of parolees. And Cullinson affirmed that with regard to the protections against unreasonable search, that parolees are no different from any other person in Iowa.
Well, Cullison and Short both, I mean, Short definitely was a general law enforcement officer, not a parole or probation officer. Cullison was actually kind of a mixed case. It started out as a parole issue, and then general law enforcement got involved. But the distinction that I see in the state's brief, and that is sometimes raised as well, it's one thing for a general law enforcement officer to perform a search of a home. That is where the risk of arbitrary conduct is greater than when a parole officer is involved. The parole officer, according to the argument, is a little more benign, and you've already set that up a little bit with your factual discussion of the parole officer trying to encourage his client to succeed. And so at least an argument can be made that it's one thing for a general law enforcement officer to do a search, but something else for a parole officer.
Yeah, and that's been mentioned in several concurrences. The difficulty with that is that it runs up against the Iowa Code, which includes in the definition of officer or law enforcement officer, parole officers, which defines parole officers as being peace officers when they're going about their duties. So at least as far as the Iowa Code is concerned, the distinction that is sometimes used to support a special needs approach isn't one that's available in the state.
Well, but we look at it from, I think we do make a distinction, and I think the cases make a distinction between more of a law enforcement function versus a parole supervision function. And clearly, the purpose of the parole officer going out there in this case has nothing to do with a separate law enforcement function. It's strictly a parole supervision, isn't it? Mission, that's what they're there for.
That was the original purpose. that brought
Right.
Mr. Scarman to Mr. King's residence, and I don't quibble with that. But it then bled into, first through a unauthorized, unwarranted, unjustifiable search of Mr. King's bedroom and the items in there. It then bled into Mr. Scarman acting, in fact, as a peace officer. He arrested Mr. King.
I'm gonna
and he
give you a-
arrested Mr. King not for parole violation, but for possession of a controlled substance.
Well, let me just give you a little hypothetical here myself. They tested him for alcohol, but I don't think that was his drug of choice, was
No,
it?
it was not.
And so if they had him drop a UA and he tested positive for illegal substances in his system, would then they have the right, would they have the reasonable suspicion in conjunction with their parole function? Would they then have had the right to expand their search?
The difficulty with that is that for them to search the entire house, under Iowa Constitution, Article 1, Section 8, what is required is that they get themselves a warrant based on probable cause. Would that,
And are you
would the
relying
results of
upon,
the UA have been probable cause?
are you relying upon Cullison for that?
Yes, among others, and there's a whole string, as Your Honor is well aware, there's a whole string of reasonably recent cases, starting particularly with Ochoa and going on, that affirm exactly the same thing. A parolee is entitled to the same rights as any person who has never been convicted of any felony.
Well, and then in Ochoa, of course, then that's where the whole specter of this special needs exception is raised and discussed, and said that under different circumstances, including the fact that it wasn't a general law enforcement officer, but it was in fact a probation or parole officer, might make the whole difference, and it might tip the scale. Isn't that what the concurring opinion says?
Ochoa, that's what the concurring decision says. It's not what the majority said.
Well, the majority left it open in Ocoa.
Yeah, they left it open.
Yeah,
But
they
in
did
short,
indeed.
we at least cited the anti-dilution language from Cullison. And the real question to me, frankly, is whether the, I think very strong language in short, applies when you have a parole officer instead of a general law enforcement officer. And if it doesn't apply, why doesn't it apply? And it seems to me that's the pip of the case.
I would reiterate, at the risk of boring everybody, I would reiterate what I've already said, which is that it flies contrary to what Iowa law currently is, and it flies contrary to what the United States Supreme Court says.
Is it
case
really
law is.
reasonable to ask them to get a warrant? They're in the house, they have, I don't know what they have. They're talking to the parolee, they have some concerns about the ankle bracelet, obviously. There's been some discussion about drug treatment, and apparently your client, kind of expressing some dissatisfaction. Could they have even gotten a warrant under the circumstance?
No, I don't think that there was any probable cause based on.
And if they had probable cause, why would you want to make them go get a warrant if they had probable cause?
Yes, in order to protect Mr. King's
All right,
and
let
everybody
me-
else's rights.
Let me pose a hypothetical to you, Mr. Douglas. Under your view, all right, the ankle bracelet goes off with this red flag indicating a malfunction, all right? Parole officer goes up to the residence, knocks on the door, no answer. Your view, they have to get a warrant before he can come back and go into the house?
There were two parole officers there. One of them certainly could have gone and gotten the warrant.
All right, so your
The other
view
said
is they
no.
can't, this is a gentleman on parole from prison, who technically hasn't completed his term. The ankle bracelet goes off indicating a malfunction. They show up, no answer. The parole officers can't, they can't enter even if, without a warrant. Is that your view?
The difficulty with, perhaps
That
I'm-
is your view?
perhaps I'm misunderstanding Your Honor, but the difficulty with emphasizing that he's technically still imprisoned is that we go down the route towards constructive imprisonment. That too is something that the Iowa Supreme Court has
All right,
rejected.
I mean,
Well, it might be,
but
it might be
answer-
impractical.
but
It
let
might be
me-
impractical. There's all kinds of exceptions to the warrant requirement.
I'm sorry, Justice Apple, could I just get, can I just get an answer to my question? Is it your view that there has to be a warrant?
Yes, in order to protect his rights against unreasonable search.
But isn't there,
Thanks, I'm sorry.
isn't there reasonable suspicion to go in the house when the ankle bracelet sends a signal there's something wrong with it?
Okay?
I mean, is that, you don't need a warrant for that, do you?
No, in that regard, I would probably compare it to the knock and talk cases,
Well,
where the person is allowed to come in by the parolee there. I don't doubt that Mr. King would have let Mr. Scarman in
So-
to check that. But then, in order to go beyond that, according to Lowe, then it requires further consent or a warrant.
To the extent there is special needs doctrine scattered around the federal cases, they focus, among other things, on the impracticability of getting a warrant. And our exigent circumstances cases, which I think are good law, suggest that under some circumstances, it's just not practical to get a warrant. If you're doing a search of houses looking for termites, it's not practical to get a warrant because you don't know exactly what house it's in. And that might get excused. Or an airport search, when you're searching for luggage, you can't say that luggage has it, that luggage has it, da-da-da. And so we sometimes excuse the warrant requirement. But is there any part of this record that shows that a warrant couldn't have been obtained?
No, absolutely none. Mr. Scarman had 3 days between January 14 and January 17, 2013, in which to go and get a warrant.
Did he learn anything new in this home visit that would have buttressed a claim of probable cause?
No, quite the contrary.
Counsel, doesn't the Fourth Amendment or our Iowa Constitution not only look at the status of the individual involved, but also the mission of government and the need for government to search? And that's why we get a bunch of distinctions in life, where you go to the airport and we're subject to search, not in violation of our constitutional rights. Why don't we focus on the mission of the parole officers and judge the constitutionality of the search based on what the objective of government is?
In the instant case, there was no need for the search to be expanded in order to serve the purposes of parole.
Do you think the parole
supervision.
officers would agree with that?
I'm sure that they probably would not, but it seems to me that
Probably a pretty tricky business. You're dealing with someone who's spent some time in prison. He kind of knows the way around everything, and probably is pretty sophisticated practice. And these parole officers perhaps need some means to deal with every one of these individuals if they're going to be successful at rehabilitating that individual.
I agree that they do need some means, and I would suggest that those means are that if there's probable cause, they get a warrant. That if you go, I've talked enough about why special needs in theory, in general, does not work. It also does not work as applied to Mr. King. Every single concern that is tied up with a possible special needs approach was answered with Mr. Scarman coming and talking to Mr. King. And as I said, at the end of that conversation, at the end of checking the monitor, at the end of testing for alcohol, Mr. Scarman's responsibility was to say, okay, we're done. Instead of expanding the search, there was nothing, no reasonable suspicion, there was nothing to justify his expanding that search.
Maybe just a hunch. Is that enough?
Reasonable suspicion needs to be a little bit more than just a hunch.
Oh, I realize that,
And
but
Iowa law has required more than even reasonable suspicion in order to go searching like that.
okay. Thank you, Counsel.
You're welcome, thank you.
Ms. Trout.
May it please the court, counsel. My name is Martha Trout, and I represent the state of Iowa. And the state asks this court to adopt a special needs exception to the warrant requirement of Article 1, Section 8 of the Iowa Constitution when a parole officer conducts a search of a parolee's home in furtherance of a parole mission. Now, up to this point, the cases that have come before you have not solely dealt with the search conducted by a parole officer. It has either been a general law enforcement officer, a mix of law enforcement and a parole officer.
In that regard, let me give you this hypothetical. Let's assume that there was some reason for the parole officer to get in the house initially, or that special needs without any suspicion would allow him to get in the house and confront the defendant. The question I have, if there was a law enforcement officer with him and said, well, let's search the rest of the house, would that be a good search under our law?
Your Honor, I think that the focus is going to have to be what is the intent of the search. And if there is some overlap, if this court were to find that the intent in going in was a general law enforcement intent, then under the prior case law, that wouldn't happen.
I'm going to assume it's not.
Okay.
I'm going to assume it's not, that the parole officer wanted the comfort of a law enforcement officer for security or whatever reason.
Right.
And the law enforcement officer then, when you get in there, says, well, I think we should search the whole house and see if there's any drugs here. Is that a good search?
I don't think if the law enforcement officer, if it changes the nature of the search from one furthering the parole mission, I think that that's a very close case because it would be more akin to the facts of Collison, where you have a mixture. It starts out as a parole search and then ends up perhaps as a law enforcement search.
Don't we have to look at what was the reason the parole officer was going to the other room? I mean, if it was to look for drugs, it's no different than the law officer to say, let's go look for drugs. Or am I wrong? Just tell me I'm wrong and why.
Well, I would disagree with that because on the facts of this case, this parole officer, his mission, the reason he exists is to assist the defendant in successfully completing his probation. And we know that this defendant is a drug addict. He has prior offenses.
I have no problem with
relapses.
him going in and confronting him. I have no problem at that point. My problem is, how do you justify him going further when a law enforcement officer couldn't, but he could? That's the issue I have. I'm going to give you all that because I don't have a problem in my mind about going in the house and talking to him in the living room and taking a urine test from him and taking a breath test or whatever else he wanted to do. My question is, if a general law enforcement officer couldn't go any further, why could this guy go farther?
Because it's consistent with his parole mission, and that is to prevent, or he is essentially acting as a caretaker for his client.
Well,
and
yeah.
the caretaker, I'm sorry, I don't mean to interrupt you, but in that function, we know that this defendant has difficulty dealing with drugs. It's reasonable under the circumstances of this case for the parole officer to search for drugs because the defendant is not going to be able to complete the parole mission, which is to come back into society and comply with societal norms, i.e. the rules and the regulations. And this defendant had a very difficult time doing that. Plainly and simply, he's an addict. And it's the mission of this parole officer to guide him through that. And so if we do go on and we do take that next step and search that, that's completely consistent with the parole mission.
But are there no limits, counsel? In this case, the state is obviously comfortable with the parole officer after determining that the bracelet was functioning and after determining that the defendant, Mr. King, hadn't been using alcohol, went into a different room of the house and started searching. Are there no limits to the extent of the search under your view of the special needs exception? For example,
The search
for example, let me just finish. It would be okay in the state's view if he went in the bedroom and started emptying out drawers, turning the bedroom upside down, tearing everything out of the closets. That would be okay?
Your Honor, I think it has to, as with any search in Fourth Amendment or Article 1, Section 8 parlance, it has to be limited in scope and purpose. And so I think it's reasonable for an officer, the parole officer in this case, to look into any place where drugs could be found. And so in this instance, this parole officer exercised it was a very limited search. He went into the bedroom, he found a glasses case on the headboard of the bed, opened it up, and found the marijuana. That was To the extent it was an intrusion, it was a limited intrusion, and it was completely reasonable with the fact that this defendant is an IV meth user. He has prior drug offenses. He did not do well on his parole. He had relapsed. He was sent inpatient treatment. He successfully completed that treatment, went to outpatient treatment, didn't like it, complained to his parole officer that, it's not doing this for me, and I
Well-
might as well go back to prison.
But the special needs doctrine really has at least 4 requirements, as I see it. One is it's got to be, the purpose of the search, which is what you're emphasizing, has to be not general law enforcement. I'll give you that. The second criteria for a special needs doctrine to apply is that the warrant requirement has to be somehow impracticable. Third requirement is that probable cause has to be impractical. And the fourth requirement is there has to be some structure, whether it be through statute or regulation, or some structure containing law enforcement, or not law enforcement, but containing government discretion. So in the case of the search of houses that might be infested, there was a protocol in place that described how the search was supposed to do and kind of cabinets. So that was right, check. You couldn't get a warrant because you didn't know which house for sure had the problem until you actually looked at it. So was the warrant impracticable? It wasn't practicable, check. And probable cause in the traditional sense was hard to show because you just didn't know, because of the nature of the problem, you just didn't know where it was. And so maybe a so-called, quote, special needs doctrine applies there. And I could go through the same litany with respect to airport searches. So, but here you've got the first of the 4 criteria. But I'm not sure you've got any of the other 3. I'm not sure that it was impractical to get a warrant. Could have got a warrant
Well, let me...
without any problem. Secondly, probable cause. Ordinarily, it's, when we're trying to do searches for drugs, probable cause is quite common. I mean, those searches are done all the time. And then third, I just don't know, and please tell me, was there some kind of rule or regulation in the record that structured the nature of the search?
Well, Your Honor, as far as the ability to get a warrant, I am not certain that under the facts of this case that
It may not have been probable cause.
that it may not be probable cause.
Right.
And to the extent relative to the third consideration, the imminency of getting it, that too.
It's not that hard to get a warrant. I mean, truly it isn't. I mean,
Well-
magistrates sign them every day. You got to have an affidavit, and you got to have certain facts. Not that hard.
But
I want to just interject something. It's just, and you can clarify for me if I'm just looking at this all wrong, but when we talk about the practicality of getting a search warrant, I don't recall ever having a parole or probation officer coming to me and getting a search warrant for a parolee or a probationer's house. To me, it's going to have to go from the parole probation officer now to law enforcement, and now we're getting it into a law enforcement. So the practicality is now you've just pushed it right back into that other area where law enforcement's involved, and we've already said that law enforcement can't go in there and do that, and we wouldn't necessarily have, well, depends on your interpretation whether you need to have reasonable suspicion or probable cause under some jurisdictional decisions, but you're going to have to get law enforcement involved. So how is it practical for a parole officer to get a search warrant?
Well, Your Honor, I think that we're hampered by the fact that we haven't had this set of facts before, so we're really in uncharted territory.
But I'm just talking generalities. How does are you aware of parole officers getting search warrants?
Your Honor, I can't say that I have. In my experience prosecuting, I've had really a handful of parole cases. And so, the concerns that Justice Appel has, I think, are the concerns that you would have relative to any Fourth Amendment case. But having said that, if you consider the 4-part or 4-pronged reasonable needs, or excuse me, special needs exception, I think that there are certain types of special needs cases. If you consider the roadblock cases, what we would call the 321 case, and there are those protocols, or you have some types that the locker search is what this court has found are okay as a special needs. In this particular case, we're not talking about general law enforcement purposes. We have to keep coming back to the fact that this is different. And it's different because there is a relationship. It's almost as if it's a caretaking function, not a community caretaking function, but an individual relationship.
But if we're going to adopt a special needs exception, we can't make it any broader than the United States Supreme Court, because they said they need 4 elements for a special needs to be good. So you can't be espousing, well, it won't work in a pro situation, so let's go broader than the U.S. Supreme Court. We have to somehow apply those 4 standards in order to comply with the Fourth Amendment, in order to apply with the federal Constitution. So tell me how those 4 requirements under the federal Constitution are met in this case. I think that's what Justice Apple was trying to get at before Justice Zager asked his question.
Well, Your Honor, I think that to the extent that if we talk about those cases, I do believe that it was met in this predicament because, first of all, we have, as far as obtaining a warrant, we have, it's going to depend on the individual judge who sees that warrant application, and perhaps.
Well, let's hope so. I mean.
Well, obviously, but Your Honor, if we have a strap tamper, which even this parole officer admitted it could be a false positive, it could be that the defendant was trying to get out of the parole. I don't necessarily know whether or not that in and of itself and the fact that he hadn't left his house is going to be enough to get you that warrant.
But if you can't comply with the federal constitutional exception for special needs, how can we broaden it? That's what I'm trying to figure out.
I'm not asking you to broaden it, Your Honor. What I'm asking you to do is to consider it, and at the very least consider it, and perhaps that you would place the purpose and reasonableness requirement on the officer conducting the search.
Let me ask this question, if I may. Was any additional information related to potential drug use gleaned during the home visit that suggested that there was drug use? I mean, I asked the same question of your opposing counsel, and he at least said that no additional information was gathered. Indeed, he argued quite the contrary, that it turned out the bracelet had its issues and so forth, and everything got cleared up. But did you learn anything in that home visit that increased the level of suspicion?
Well, Your Honor, I don't necessarily think that it increased the level of suspicion, but I don't necessarily think that based upon the relationship that the parole officer had with the parolee, that he had to take him at his word and say, let's, for example, say, well, why didn't you leave for 2 days? He said, well, I was sick.
Yeah.
Was he sick because he had the cold or flu, or was he sick because he went on a bender? Which was a concern for this particular officer. And so what he did was take the next step and look in a place where he believed that drugs could be found. He goes straight to a glasses case and he finds marijuana.
Would you concede there was no probable cause?
Probable cause for that, that's correct, Your Honor. But that's the whole reason that we asked this court to adopt a special needs exception.
Well, even under special needs, if you meet my 4-prong test, you still need reasonable suspicion, which needs to be more than a hunch, according to the cases. Do we even have reasonable suspicion here?
I believe so. I believe we do have reasonable suspicion
More
based
than a hunch?
upon. Well, we have the defendant's own admissions 3 days prior that he's not doing well and he might as well go back. And he has had difficulty while he's on parole. We can't discount the fact that there's a relationship that has been created between this parole officer and the parolee. We can't discount the fact that when you read the testimony of the parole officer, he's acting more as a social worker or a counselor for this defendant, trying to make sure that he stays on the straight and narrow. And so I think that when you're looking at the general purpose and intent of this particular search, it is not for a general law enforcement purpose, and it is to protect or to help this defendant, to guide this defendant so that he stays out of prison. And Your Honors, One other thing I'd like to point out, I disagree with a statement made by the defense attorney where he said he arrested him for the possession. This parole officer arrested him for a probation violation. He called the Sioux City Police Department and had this police department transport him. This parole officer did what was part of his mission, and that was to assist this defendant in successfully completing his probation and with the help that he would be able to return to society as a productive member. I see that my time is out. I request or ask this court to carefully consider and adopt a special needs exception to Article 1, Section 8 of the Iowa Constitution.
Thank you, Ms. Trout. Mr. Douglas, you may present your rebuttal argument.
I'll very briefly take up the last point first. Mr. Scarman and his companion, Mr. Rusick, arrested Mr. King and handcuffed him and then called for the Sioux City Police. The charge that was brought against Mr. King was one in possession of a controlled substance.
Well, yeah, but the probation officer...
I believe that I'm sorry.
The probation officer didn't bring the charge. I mean, the suggestion is, and I think it's correct, that the probation officer determined there was a violation. I'm sorry, the parole officer determined there was a violation of parole based on discovery of marijuana, and his parole was being revoked. And then the police and prosecutor later piggybacked on and charged him with the crime. Or tell me what the record shows.
Okay, I would have to double check the record. My impression is that Mr. Scarman arrested Mr. King for possession. Obviously, that also is a parole violation, so both might well have happened at the same time. I'm simply going to say at this point that I believe it was for possession, but I could easily be wrong. With regard to the four criteria, I want to start actually with the fourth criterion, which is the structure. In Griffiths versus Wisconsin, there's a great emphasis put on the administrative regulations that Wisconsin had in place. So far as I could tell, the Iowa Administrative Code and Iowa Code 906 doesn't have anything comparable in detail to what Wisconsin had. So that if Iowa were to adopt the special needs, there'd be some work needed on that, and that work hasn't been done. So I don't think we're in a position to adopt the special needs because the structural underpinning is not there. With regard to the distinction between parole officers and general law enforcement officers, I think in some respects it gives too much and too little. It perhaps gives too much to the parole officer to emphasize that social work role. I grant without any argument that that is a role. But obviously they also are authorized by the Iowa Code 906 to parole officers while performing their duties as parole officers are peace officers and have all the powers and authority of peace officers.
Well, sure. So if you do a home visit and in plain view, there's marijuana scales and whatever else, the officer can make the arrest,
Yeah,
I take it.
so the parole officer can execute an arrest just as Mr. Scarman did. That also then suggests a possible answer, and again, this is guesswork on my part, but it suggests a possible answer to whether parole officers at least have the authority to get a warrant based on probable cause. It seems to me if they have the same authority as other peace officers, yes, they can go ahead and get a warrant.
We have rules or statutes that say any peace officer, any law enforcement officer can get a warrant? I mean, just because nobody saw it doesn't mean they can't do it. I mean, do you know what the rules are dealing with search warrants and things like that about who could present a search warrant to a neutral magistrate? I believe it's any peace officer, any law enforcement officer.
That's my understanding also. Again, I would want to double check on that. I've been potentially burned once. I don't want to be burned twice, but I think Your Honor is indeed correct that any peace officer can do that. With regard to the impracticability, I think I've already addressed that. 3 days in which to get a warrant if there was ever probable cause, which the attorney for the state has conceded there was not.
Well, let's focus on the time limit between the time they got in the house and saw nothing was wrong till the time they searched the bedroom. Was there time to get a warrant if they did have probable cause?
I'm sorry, would you repeat the question, please? I'm
From
not sure I followed.
the time they went in the house and did their inspection and had their discussion with the defendant, was there still time to get a warrant if there was probable cause?
There were two of them there, presumably Mr. Bruska. Presumably Mr. Scarman would have stayed there, and Mr. Rotska would have gotten the warrant.
Or one of them,
Either way, yes.
or
yes,
one of them
that
could have
happen.
removed them from the house too, so he can't do anything.
Yeah, and I guess I wanted to ask you the same question. Obviously, you're involved in this perhaps on a day-to-day basis more than I am. Do you ever have a parole officer actually go to the judge or a magistrate and get a search warrant? Or do you end up, you go to law enforcement, who then goes to the judicial officer and actually gets the search warrant? Have you ever had an example where a parole or probation officer has actually gotten a warrant? So we say that one guy's there and the other guy could go get a warrant. Have you ever seen that happen?
No, I have not seen it
Okay,
happen. That
that's-
doesn't mean that it can't happen. And they, at least per the code, they certainly have the authority to do so.
Of course, prior to Baldwin, they all thought they had consent because they had the parole form had waiver of all the rights, and that didn't make it in Baldwin just a year ago.
Yeah, as a defense attorney, one of the main problems I've got is that my clients are too ready to roll over and give them consent regardless of anything else.
Yeah, and I don't
and-
think anybody's arguing consent here.
No.
Or arguing the parole consent, which has already been decided by this
Right.
court, but, okay. Thank you.
Thank you. Thank you, Mr. Douglas.
Thank you.
Case of State versus King is now submitted.